Thank you for all your lovely comments on the last Laurence Fox video, and a few queries arose, so I'm going to try to address those. I mean, I might have to do some more follow-up videos, but some specific points. Fox was actually sued by 3 people, but he had a minor success in that he got one of the claims struck out, and if I explain why that was, that might give a little bit more detail and explanation as to why the other 2 claims succeeded. But also I can look at why Fox lost his counterclaim, but the judge decided he didn't need to define what racism was or what being a racist was, or indeed whether Fox was a racist or whether it was a reasonable opinion to believe he was. So to give a bit of brief background, you probably all know anyway, Fox got into a bit of a Twitter spat with some people, and they accused him of being a racist. And he responded by tweet. And one of the tweets said, "says the P word," you know, that word that YouTube doesn't like me using. And another tweet said something similar that, you know, that's great coming from a P word. However, with regards to the third one, somebody had put a tweet saying anybody who employs Laurence Fox does so knowing he's a racist and is clearly on board with racism. In response, Fox quoted that tweet, but he said anybody who employs the claimant does so knowing she is a P word and that they're on board with P wordism. So that was a direct response where he took her quote and just inserted the word. Now, what the judge said when looking at these claims, he said, had Fox expressly said, you know, I am no more a racist than you are a P word, then that would be okay. And that is actually what happened with that third claimant. And this just goes to show how the difference between owing hundreds of thousands or millions of pounds in defamation claims and, you know, actually winning the claim and receiving your costs is often just a matter of whether you screenshot something or whether you make it clear you're quoting. Because by responding directly and quoting that tweet, the court said, albeit on appeal, that it would have been clear to anybody that he was merely doing this tit-for-tat thing and he was just being hyperbolic because, you know, because of that quote. I mean, the first instance judge said, actually, well, you know, that's a matter of fact whether it crosses that line. But when he went to appeal, the appeal court said, actually, yeah, you were right on that one. So that one gets struck out. So he will have got some cost for that. But this just goes to show, whenever you're doing anything, when you want to make clear that it's either an opinion or you're being hyperbolic or sarcastic or satirical, or just expressing an opinion generally, if you actually screenshot or quote what you're commenting on, because to succeed in a defensive opinion in defamation anyway, you have to point to the facts that your opinion is based on. You also have to have a reasonable belief that those facts were true. Whether or not they are true, that's not necessarily determinative. But in this particular case, they said, well, you know, by quoting that, he's made it very, very clear. So remember that if you're ever on social media and you want to do something like this, make it very clear that you are saying, well, here's the factual basis. Somebody has said this or somebody has done that. Because of that, I have come to the conclusion, and therefore it's my opinion, that that amounts to, you know, whatever you know, disparaging comment you want to make about them. Because the idea is that somebody could come along, look at what you're commenting on and go, I don't agree with you. They can form their own opinion because you've given them the necessary information. So that's a very, you know, that's something that is well worth bearing in mind, you know, because people get done like on social media all the time for defamation and end up paying out tens of thousands of pounds. It's true to say that the courts tend to see things like Twitter as very fast moving and, you know, it's got a sort of transient quality. So they've said the best way of responding to defamation on Twitter is just to put your side of the story out. But you've got to be very careful because obviously that's what Mr. Fox tried to do. But as to, you know, why he lost his claim, it used to be, prior to 2013, that a major difference between libel and slander was that libel, that is to say, some people say it's written versus oral. That's not quite true. It's more sort of permanent versus transient. So, you know, a radio show or a television program can be libel, even though obviously it's not written down. But libel used to be actionable per se. Somebody must have said something bad about you. You must have suffered some harm. Here's a wad of cash to make up for that. Slander, however, you had to show an actual loss. You couldn't just sue and say somebody slandered me. They'd say, well, yeah, well, what damage has that done to you? Well, they've just slandered me. You can, assume it's caused me harm. No, you had to show actual loss, with a few exceptions. If you disparage somebody in their trade, profession, or calling, basically saying they're bad at their job, then that was actionable per se. Saying people had certain diseases, mainly the old sort of Victorian ones, like consumption and things like that, that was actionable per se, because people would shun and avoid you if they thought you had diphtheria or whatever. And also the impugning the chastity of women, that also used to be actionable per se. However, post 2013, the Defamation Act, Section 1 says, a statement is only defamatory if it causes or tends to cause serious harm. If you're a business institution, that's serious financial harm. But if you're an individual, it can be harm generally. But you actually have to put in evidence of this. There's no longer the assumption that the statement caused you harm. So what harm did Fox say he suffered? Well, he said, I have lost loads of work. I'm now unemployable because of these tweets. But it was up to him, it was down to him. He had to put in evidence to show that. So what did he do? Well, the court did point out and said, you keep talking about your agent here, but we notice you haven't actually called your agent or asked her to give evidence as to, when your circumstances, when declined and when you became unemployable. But some material did go in. And unfortunately for Fox, one of them was a letter he'd sent to his agent prior to these tweets saying, you've got to stand by me, please don't dump me, look, I'm just standing up for what I believe in, I know people don't like that, but if you abandon me, everybody in the industry will abandon me. And similar ones where he was saying about, I've lost loads of work. I mean, that was a lot of it was on the back of the Question Time. When he was on Question Time, he posted lots of things after that, internal correspondence saying, I'm losing work on this, and indeed publicly commented and said, since I went out there and stuck my neck out and told the truth, I have suffered, but I'm willing to be a martyr for free speech. So the problem there was that the judge said, you fail on the first hurdle, because this can only be defamatory if you've suffered a loss, and it's a consequence of that. There has to be a connection. The mere fact he has suffered a loss, unless it's down to the person who did the wrong. I mean, this is a very similar thing. This, say for instance, you run somebody over, and on the way to the hospital, the ambulance crashes. Or they were going to have a heart attack anyway just before you ran them over, something like that. Well, your wrongdoing, you did some wrong, but if that's not actually the cause of the injury, then there's no claim there. And that's the same in defamation. So what the judge said is, look, mate, your own evidence shows that you were already unemployable before they said this. You haven't been able to show that those tweets changed one thing about your employment circumstances. So that's it. It's not defamatory, Section 1. So we don't need to look at anything else. We don't need to establish, whether there's any truth to the statement, or whether it's a reasonable opinion, or whether any of the defences apply, because you just fail at that first hurdle. So that's why he's lost, and that's why all this issue about what is racism and is Fox racist? Is it a reasonable opinion? The judge said it's all irrelevant. So that was never tested, which is interesting because, like I say, I think Fox's lawyers did put a pretty interesting and reasonable argument when they were arguing for the jury, saying, look, a judge will deal with this, the danger is a judge just looks at the bench book where it says, racism is an outcome-based thing, and if somebody says something's racist, it is, versus the test, which is what would your average, ordinary, reasonable person think. But the judge did actually go into that, and said about, what may or may not be racist is something that is, people have very differing opinions on. and it's not clean cut. It was clear that the judge wasn't going to just be bound by what it says in the equal treatment bench book. He would have made a decision, but then said, I don't actually need to make this decision because this claim fails at the first hurdle. I mean, sometimes they will actually just, thinking about appeals in future, they'll say, and if I'm wrong on that, I find that the defence would have succeeded. But in this particular case, there's just no chance of an appeal because, it's not that anybody can argue, oh, well, they misinterpreted the evidence or they didn't put enough weight on it or they put too much weight on irrelevant factors. I mean, Fox, by his counsel's own admission as it came out, they had to accept that his career had pretty much tanked, whether fairly or unfairly, his career had tanked well before these tweets. So there you go. I hope that's cleared a few things up. I'm sat in the basement of Cafe Kino in Bristol, which is a cafe I really like because I've got a meeting with the bar standards board this evening. Just to chat. I'm not in trouble for once. Yeah, so there you go. If you did enjoy that or found it vaguely useful, vaguely interesting, possibly vaguely accurate, please feel free to consider liking, sharing, subscribing and all that YouTubey sort of thing.